Indemnity. There are two aspects which are important. One is indemnity, the other is guarantee. Indemnity is associated to cover the loss, whereas guarantee is related to the default committed. This is the definition of indemnity, and indemnity is discussed in the Contract Act. There are only two sections which deals with indemnity, section 124, 125. Contractor indemnity and surety are discussed in the Act. Negotiable instruments, sale of goods, surfacey, none. The appropriate answer is Contract Act. Negotiable instrument deals only with three items or three instruments. They are called negotiable instrument, as we have already seen: promissory note, bill of exchange and check. And surfacey act is related to Securitization Act, which deals with something else. A contractor indemnity has two persons. One is the indemnifier, the other is indemnified. It is for the reimbursement of loss. In an indemnity, the risk is contingent, whereas in a guarantee, the liability is subsisting. The above is correct, the above is incorrect. For indemnity, the risk is subsisting, and for guarantee, the liability is contingent. For both risk contingent, liability subsisting, the correct answer is A, the above is correct. Contingent means may take place or may not take place. Contract indemnity, as I told earlier, two persons, indemnifier and the indemnified. Number of contract 1, associated with loss. Banker is associated with indemnity to protect against the possible loss. Issuing of duplicate or triplicate demand draft pay order, as the case may be. Issuing of duplicate or triplicate term deposit receipt. Settling the claim in favor of the legal heirs while minor interest is involved. Any other issue to protect the interests of the bank. Let me explain one practical aspect which has taken place in one of the banks some years ago. At that point of time, the KYC norms were not in place. So the bank had opened an account in the name of a person who had come from the North India to the Western India. The account was opened. At the time of opening of the account, they asked the name of the person. The person was working with a sofa company. He said Sofa Wala. Account was opened in the name of Sofa Wala. Later on, that particular person died. And he died in his native place. And that particular account was maintained in this area. So his wife approached the bank for getting the money. At that point of time, nomination was not in place. So the legal heir had to get it. The wife had to get it. The problem for the bank was, as per the records of the bank, the account was in the name of Sofawala. As per the death certificate, the original name of the particular person was appearing. Now there has been a confusion how to make the payment. Ultimately, a decision was taken. And when the opinion was called for, somebody has said, go for success certificate. Somebody has opined, let that particular person give a declaration. Somebody has suggested, let the person can give a statement stating the facts. Somebody has said something else. Ultimately, the bank has allowed the particular wife of that person to give an indemnity. Thereby, the bank's interest was protected. In the indemnity, the facts were written. The difference between declaration and giving a undertaking and indemnity is, in indemnity, it is written on stamp paper, and indemnity will specifically cover the loss. At the time of giving the money, there was no possible loss. Probably if the loss was to come later on, that particular indemnity would protect the bank. When things can be done simple on a simple matter, the things have to be used. That is the reason indemnity and knowing about indemnity is important. Bankers are required to know about the provisions of indemnity, and they do use that. This is what section 125. When sued, entitled to recover all damages, all costs, all sums, subject to the contents of the respective indemnity agreement executed. Rights of an indemnity holder. This is what it is said. he is entitled to indemnified by the indemnifier. Example for indemnity, general insurance policy. Whenever a person is taking an insurance policy, general insurance policy, it is covered under indemnity, because one of the principles of insurance includes indemnity. So it is not applicable to life insurance policy because the life of a person cannot be replaced, whereas the loss incurred can be reimbursed. The damages paid by him, the costs required either to file the suit or defend it, any amounts paid in connection can be recovered. So there are varying opinions from different courts. Now let us see what is guarantee. There are two types of guarantees. Guarantee is an assurance. Whenever there is a default, the person who was assured to repay, he will be repaying, or assured to do something, he will be doing that. As far as the bankers are concerned, there are two types of guarantees they come across. One is accepted by banks, the other one is issued by banks. The first one is, whenever a person is given a finance, as a creditor banker, he takes the personal guarantee of a third party, or a surety as he is called. The other is issued by bank. On behalf of the customer, bankers give bank guarantee. And now we will be discussing more about the bank guarantee. And guarantee is discussed in the Contract Act. The word guarantee is not used in the Contract Act, but the word surety is being used. Bank guarantee, it is issued by a bank on behalf of its customer and in favor of third party who is called the beneficiary. There are contracts involved like between the customer and the beneficiary, between the customer and the banker, between the banker and the beneficiary. At the request of the customer, Raja and Company, Bank SK decided to issue a bank guarantee in favor of a government department. Raja and Company customer, Bank SK surety or guarantor, government department beneficiary. In respect of the finances extended by banks, the same would be secured by the personal guarantee of the security of the borrower. Additionally, it could also be secured further personally when a third party is giving his guarantee. Bank in this case would be the creditor because they are lending the money to the borrower. In bank guarantee, the role of the banker undergoes a change. The banker becomes the guarantor or the surety, whereas the third party in whose favor the bank guarantee is issued becomes the beneficiary. The customer is the debtor. So you have seen the earlier slide. Customer who has the obligation to repay. Bank XK is the surety which gives the guarantee. Government department who is going to get the benefit, it is called the beneficiary. Different types of bank guarantees are available. Financial guarantees in lieu of earnest money deposit, performance guarantees, deferred payment guarantees. Bank guarantees. Before issuing the bank guarantee, the draft should be approved by the appropriate department of the bank, so that later on there should not be any problem on making the payment. Non-fund based credit. Credit in bank is the finance being given to the borrowers. Fund based means the money is lent by the bank. Example, a person is purchasing a car out of bank finance. It is the credit given by the bank to purchase the car. That means bank is lending their money. A person is taking a housing finance. Money is given by the bank. A person is taking a loan on the security of gold ornaments. Money is given by the bank. These are all fund based credit that will be appearing within the balance sheet as an asset. Whereas non-fund based credit, a bank guarantee, letter of credit, these are all the commitment given by the bank right now. Money is not parted with. Later on, in case of need, when need arises, there is a possibility of money is being paid by the bank. Till such time, a promise and undertaking is given by the bank on behalf of the customer. So these things will not be appearing within the balance sheet. They will be shown outside the balance sheet. They are also known as off balance sheet items, and they are also known as contingent liability of the bank. Reserve Bank is concerned about the bank's contingent liabilities, especially bank guarantees and LCs, because the banks in an anxiety to do business, to earn income, they go on committing without protecting themselves. Later on, when the problem comes, they are not in a position to handle such things. That is why Reserve Bank is more concerned, and they are advising banks to be more careful while going to give commitment on letter of credit or bank guarantees. Non-fund based credit, off-balance sheet item, all precautions will be taken to protect bank's interest. It is a contingent liability. The guarantee has got certain features which include amount of the guarantee, period for which the guarantee is being issued, protective clause, claim period, beneficiary, or some of the important aspects. These are to be understood properly, and they should be in place to avoid complications later on. If claim has come from the beneficiary, utmost importance to be given and due action to be taken without any further delay, because the bank guarantees are always issued payable on demand without demur. Without demur means the person who is going to make the payment, that is the bank which has issued the guarantee, will not question anything. They will accept the demand of the beneficiary and make the payment. If there is a delay in making the payment, that will definitely invite complications, and that is the reason the bankers will have to be more careful. Duration, amount, other terms and conditions, protective clause, claim period, bank guarantee commission, payment to be made by the bank, claim, revocation, invocation, recall, demand. These are the various terms meaning the same thing. When the beneficiary is asking for payment, it could be called claim, revocation, recalling, or invocation, or demanding for the payment. On demand will pay without demur. Terms and conditions of the guarantee is essential to be understood, and it should not be ambiguous. Within the guarantee period as agreed, the payment should be made. No injunction prohibiting payment. Courts would not prevent a bank to settle the bank guarantee amount unless otherwise there has been fraud or forgery involved. The courts will interfere only when there is a malified intention or fraud or forgery takes place. Once the bank issues a guarantee, the court will not ask the bank to stop the payment unless the court is satisfied there is some problem involved relating to either fraud or forgery or some malified intention. Counter guarantee. This is one of the very, very significant aspect of bank guarantee. When a bank is giving a guarantee, they are expected to protect their interest. Lot of loan documents are taken. One such particular document, legal document, is called counter guarantee. Proper and adequate collateral security and duly secured with appropriate legal documents and manner in which it has to be procured and secured. It could be by way of pledge or mortgage, as the case may be. Later on, if these things are omitted, and later on if they wanted to secure, it may not be possible and the party may not cooperate with the bank. To avoid complications, it is advisable, expected, the banker has to take all the precautions before committing on a bank guarantee. Bank guarantee is the commitment given by the issuing banker guarantor to the beneficiary. If the claim made by the beneficiary within the guarantee period and as per the terms and conditions of the bank guarantee, the bank should make the payment without fail and also without any delay. This is very, very crucial, very much important. Even though many of the bankers are experienced, still there are cases where things are not taken proper shape and banks are put to loss of inconveniences. That should be avoided. With effect from 1st January 1997, Section 28 of the Contract Act has been amended. Standard limitation clause Earlier, banks to insist that beneficiary to enforce claim within a period of 3 or 6 months, failing which bank's liability was extinguished and else the rights of the beneficiary not applicable. So there has been a change. The presently section 28 amended is being followed. Prudent, that means practical banker, for the bank to insist that the bank guarantee to be returned duly cancelled by the beneficiary, or banks also insist on appropriate certificate from the beneficiary that there are no claims under the bank guarantee and preserve the same. Once the beneficiary is not sending back the original guarantee on the due date or after the due date, it is the responsibility of the bank which has issued the bank guarantee to insist on a letter or an undertaking from the particular beneficiary that there has been no claim which is going to be made by them. As far as the bank is concerned, the liability is completed. And that is very much crucial, because bank guarantees are being issued to government departments also. They will have to be more careful in getting a confirmation from the beneficiary to avoid complications at a later date. Till such time, the cash margin and the security of the debtor customer to be held by the banker. Here, the beneficiary is the government department. The bank did not make the payment. Then the beneficiary can sue the bank within 30 years. Generally, it is 3 years limitation period. As far as the government department is concerned, it can go up to the period of 30 years. So today we may not know what is happening. Later on, if problem comes, the bank has to face the problem. To avoid that only, it is insisted that a commitment or an undertaking or a letter from the government department, there is no claim made after the expiry period to be got and kept with the bank. Identify the role of indemnity. Bank has given a loan to C on the surety of F. Bank has settled a death claim in favor of minor legal heirs. Bank for issuing a demand draft to a student. Bank for issuing a credit card to one of the valued customers. The first one is the bank guarantee or the guarantee. The third and fourth are the services of the bank. And the second one is the appropriate answer. To take care of the possible loss, the bank is insisting on an indemnity whenever they are settling the death claim to a minor or minor legal heir.